Okay, everyone. I think we are about ready to get started here. Thank you so much to everyone for joining. Please feel free to turn your camera on so we can have a nice and interactive webinar discussion here. My name is Felina Fleck. I'm the Assistant Director of the Graduate and International Programs Office at the University of San Diego School of Law. That is a really long introduction sentence for myself, but we are so happy to have you join us here today and for our office to be able to host this free webinar. It is my absolute pleasure to be joined with Professor Robert Bowen, one of our very own professors here today. Thank you so much for joining us, Professor.
My pleasure. My pleasure.
To say a few things about you, to allow me to introduce you, Professor Bowen is an international trade attorney who has dedicated more than 2 decades of his career to the laws that apply to global trade. So you've seen it all so far. As an attorney advisor to the United States Department of Commerce, I have read that your focus was on the World Trade Organization and the formulation of United States government trade laws and policies. And then in the private practice and corporate sector, your focus was a lot on customs laws, export control laws, trade sanctions laws, and foreign direct investment. My apologies.
Correct.
So thank you. You are obviously the expert on this subject, not me, as I'm still learning to pronounce the words correctly. Thank you so much for joining us. I will hand it over to you to share your amazing knowledge with us all.
Well, Felina, thank you very much. That was truly too generous of an introduction. The bar has already been set really high. Let me see what I can do here. First and foremost, I hope all the technology is working. I think I've got decent Wi-Fi, and I'll hold my breath. But please, if for whatever reason anyone notices any freezing or these blank stares going on because of a technology issue, just let me know. Sometimes the chat box is good for that, just to let the speaker know that he or she is frozen. So
We will.
excuse me. I do absolutely want and strongly encourage questions. I think we will set aside some dedicated time at the end for Q&A. I think in a virtual event like this, that probably works best. If we were in person, I would be delighted, to have hands going up and feel free to interrupt and whatnot. But I think in this context, it's probably going to work best if we sort of backload questions till the end. But again, though, absolutely invite robust questions. I will do my best. I will do my best. What Feline and I thought would be a wise investment of time today would be for me to provide a bit of a synopsis and background in with respect to 3 really dynamic areas of not just trade law, but of law in general, because of their historical importance, let alone some current cases and controversy involving these areas of law. And so, what I propose to do is to go through each of these 3 areas of law, providing a sense of a historical background, a brief synopsis of what the substance of some of these laws actually is and what it actually looks like and feels like in practice. And then obviously providing a couple of examples, because I think it's always helpful and useful, to maybe hear a little bit about what some of the concepts are, but then also being able to tie that to some examples, many of which, quite frankly, we're probably reading about every time we turn on the internet, just because there is so much going on with respect to these areas. What I would then do right at the end of our time, or at least of my presentation time, I would like to actually have a word about what all of this means with respect to careers. As Felina said, I am absolutely privileged to teach at the School of Law, and it is a common curiosity that a lot of my students are asking about, and some with a little bit of puzzlement. But we're reading about all of this, but what does this actually mean as a potential career option for a lawyer or a law school student looking at his or her career in the future? Happy to do my best to try to answer some of that as well, too. Okay, well, let's jump right into it then. The first sort of subcategory that I would like to give a bit of an overview on today are export controls. Export control laws, as many of you may know, and maybe have had some experience with, are laws that most developed countries have, but some at varying levels of sophistication than others. But these are fundamentally laws passed by nation states that control and restrict the items, and I want to come back to that term. That's somewhat of a term of art. Items that can be exported out of that territory that is controlled and regulated by that nation state's government. Now, one term of art, which I'll try to keep to a minimum here, but the term item is usually what is referred to, for example, in U.S. export control laws, to include hardware, software, and intangible technologies. And I think that's one of the key initial points. Export control laws in most countries, including the United States, clearly and uncontroversially apply to proposed exports of hardware, software, and intangible know-how, if you will. Um, the United States has particularly developed export control laws in that they're long, they're historic, they're storied. They largely came about in a very meaningful way over the course of the 20th century. But a historical footnote, they actually go all the way back to the colonial days when the colonies themselves actually passed ordinances prohibiting the export of certain items to Great Britain, believe it or not. They really do, at least in the United States, go back that far. But fundamentally, the way I usually think about export control laws is that they apply and they work and they function almost as a net. It's a legal net that is put over and, if you will, around a certain country and the companies and the individuals in that country that provide some guidance and some controls and some restrictions on the hardware, software, and intangible know-how that can leave, if you will, that net that has been laid over top that particular nation state. Now, the United States takes that one step further. And by the way, mark this as a little bit of a practice pointer. It's now not only the United States, because China is also now starting to learn some lessons. But the United States' export control laws also apply to transactions entirely outside the United States when the items related and involved in those transactions contain a certain level of U.S. content. And this is something that has been specific and unique mostly to U.S. export control laws for decades. But some of you may have noticed just a couple of weeks ago, China announced some export control laws on certain critical minerals or rare earth minerals, if you will. I believe for the first time, China has now included that aspect of extraterritoriality to its export control laws, just like the United States' export control laws have been extraterritorial in their application for years and years, and indeed decades and decades. The United States in particular is unique in that there are two core but different sets of export control laws. One set is the International Traffic in Arms Regulations. You may be familiar with that by its acronym ITAR, ITAR. The ITAR are the U.S. export control laws that apply to defense articles and defense services. So these are the export control laws that apply to munitions items, items that are, if you will, specifically designed for a military application. The U.S. has a separate set of export control regulations that apply just to defense articles and defense services. Conversely, the other body of U.S. export regulations is called the Export Administration Regulations, euphemistically known as the EAR. The EAR applies to what is called dual use items. Dual use is a bit of a misnomer, or it's not entirely clear, initially at least, what the term dual use means. A dual use item in the context of an export control discussion means little more than something that was intended to be used in a commercial and civilian application, but that could just as easily be used in a military application. And we all have these items in our homes. Your computer, your phone, the chair you're sitting in, the table you're sitting at, maybe the pen or pencil that you're holding in your hand. Those were all items that were not designed for a military application. I doubt any of us has like a number two lead pencil designed, for a military purpose specifically. But these are items that, even though intended for a commercial application, can still be used for a military application. After all, ministries of defense around the world need chairs and tables and pens and pencils and even computers and phones. Well, the U.S. has the ear to govern that set of items, and that's referred to as the dual use set of export control laws in the United States. Now, by way of a couple of examples, I'm sure all of us by now have been reading a lot about U.S. export control laws on certain powerful semiconductor chips and integrated circuits, specifically those that enable and empower artificial intelligence. When you read about, new UX export control laws on, for example, like NVIDIA, like the most advanced NVIDIA AI powered chips, that is a reference to the US EAR and controls that have been incrementally put into place in the EAR on such items, really going back a couple of years. But this year, 2025, has been specifically dynamic on the export control laws in the EAR on things like the NVIDIA chips. And it's not just NVIDIA's chips, the manufacturing equipment that is used to manufacture these types of very high powered AI chips are also now subject to significant export control laws, and there has been a lot of publicity just in the last 6 months on that very subject. Another good example, common example perhaps, of export control laws has to do with U.S. export control laws applicable to Huawei. Don't forget that export control laws can actually create a significant barrier around an entire company, in this case, Huawei, in addition to around an entire country, like, for example, North Korea. Under the EAR, the vast, vast, vast majority of items subject to the EAR actually would require U.S. government export licensing to go to North Korea. But the Huawei restrictions are some that maybe some of us have heard about, maybe we have some experience with. The EAR now has significant restrictions on items subject to the EAR that might otherwise be destined for delivery to Huawei. Um, I will quickly transition to tariffs, but let me just say by way of a quick current event, literally, I think right now President Trump, I believe maybe is in Japan today, but I think soon will be traveling to South Korea. You may know, but the president's team and President Xi Jinping of China's team have been meeting already on the sidelines, preparing for a possible potential meeting between the two presidents. One of the subjects that has been discussed and may be discussed if there is a presidential level meeting are, in fact, EAR controls on some of these semiconductor chips and manufacturing equipment. So stay tuned. These are actively under negotiation and discussion between the two governments, including and specifically at the presidential level. Again, happy to take any questions in a couple of minutes on export controls. But shifting gears to tariffs. Um, I have no doubt I have been hearing and reading a lot about tariffs over just the last year, let's say. But tariffs are actually not new. Tariffs are not new at all. And in fact, tariffs, just as a concept, actually are thousands of years old, quite literally thousands of years old. What in concept is a tariff? Well, I think it helps to consider that a tariff is a transactional tax that is imposed by a customs service that is inspecting and maybe admitting hardware items into a given country. So they are transactional taxes applicable to the imports of hardware into a given country. We could spend a lot of time breaking down each element of what I just said, but I think the key thing for our purposes here today is that these really truly do function like taxes in the sense that they are a cost imposed by public laws and government agencies on a given transaction. So you can almost think of it like another good example. A transactional tax would be a sales tax. You go grocery shopping, you put gasoline in your car, you're paying sales taxes at each such transaction. Think too about the importation of hardware into a given country. That is the transaction that, if taxed the way tariffs do, is the kind of transaction that I'm talking about. I think the other thing that I do want to stress about that basic definition is that it only apply, or tariffs only apply to the importation of hardware. Now, certain countries have, and for a long time, have been experimenting with, if, how, and why might they consider imposing tariffs on the importation of software and the importation of intangible know-how. We don't need to spend a whole lot of time on this other than just making a mental note that it has not been lost on certain countries that maybe they should give this some consideration. But I believe I'm right when I say that no country that I'm at least aware of has figured out actually how to do this. Because if you think about it, I mean, the importation of hardware can be tricky enough. It's one thing to contemplate, at least in the United States, but it's not just the United States. There are customs officers at all ports of entry, major airports, for example. Sitting here in Southern California, we've got some major ocean ports. As there are ocean ports, throughout the United States, all of our coastlines. Other countries have the same. And then there are also land border crossings. In San Diego, Tijuana, great example, right? So at each of those major ports of entry, there are U.S. Customs and Border Protection officials assessing whether or not certain hardware can be granted legal admission into the United States. That's challenging enough. I don't think that it would be administratively feasible to contemplate how that would work in a cloud environment, for example. Like, how would you really negotiate and differentiate if, how, and when, say, for example, intangible know-how transacted from one country to another country to another country in a way that would allow the assessment of tariffs? But going back then to that definition, let's then work with the definition of a tariff as a transactional tax that is imposed upon the importation of hardware into a given customs territory. Well, historically, this has actually been very controversial. So, some of the current controversies that we probably have all heard about and read about in some ways are not new. After the Second World War, the General Agreement on Tariffs and Trade came about, the GATT. You probably have seen the acronym, know about it perhaps, but GATT 1947 eventually became what today we refer to as the World Trade Organization. The World Trade Organization came about in January of 1995, but it really is just the current day, albeit expanded version of the GATT, and the GATT started in 1947. But from GATT 47 to today, under the auspices of the World Trade Organization, one of the key areas that the GATT and the WTO have been focused on are a series of agreements that member states or contracting parties have entered into to determine tariff practices that are acceptable and agreed to and those that are not. My only point in stressing some of this here today is simply to indicate that there is a body of agreements on the subject. There is an overarching and overriding international institution that enforces some of these agreements. The United States is not only a member of the WTO, but was actually one of the founding members of GATT 47, and in fact was arguably, I think it's safe to say, the indispensable founder of the GATT when it began in 1947. So the United States, like a lot of our other major trading partners, is a member of today's WTO and therefore is subject to the agreements that it entered into that include tariff practices. Well, why is it that tariffs tend to be and historically have been controversial enough so that they have found their way into internationally enforced disciplines? There are a couple reasons for that, and we can touch upon a couple of them briefly. One is that tariffs, if not used in a certain way, can become instruments of discriminatory trade. There are two key principles of non-discrimination that are built into today's WTO, but historically also GATT 1947. One is called the Most Favored Nation principle, or MFN. The MFN principle suggests that an importing country will assess the same tariffs on the same items, regardless of where those items came from. Let me give you an example. I'm holding an ink pen in my hand. The MFN principle would suggest that when a country is importing this ink pen, regardless of whether this ink pen was manufactured in China or in Malaysia, it will assess the same tariffs against this ink pen because it's the same article, whether it was manufactured in China or in Malaysia. That stands in contrast to policies and practices that would actually, for example, assess a higher tariff if an item were imported in one country versus the same exact item being imported from another country. Um, I should add too, before we get any further, most tariffs are assessed as a percentage of the value of the items being imported. And that's why, for example, as I'm sure you probably have seen, there has been a lot of publicity given, especially in 2025, about 10% here, 15% there, 30% there. Well, that is in reference to the fact that most tariffs are assessed as a percentage of the customs declared value of the entry that is proposed for admission into a given country. And so the MFN concept is that the importing country in its tariff practices is not to discriminate between two, if you will, foreign originating countries. And in my example, between China and Malaysia. The second key non-discrimination principle that is lurking, if you will, behind the tariff idea is national treatment. Now, national treatment includes a couple of other practices, but it's also something to keep in mind as you are reading about tariff developments, because in spirit, the national treatment idea is that a country is not permitted by law to treat imported items any worse or any better than it treats domestic competitors. And that is to say, it actually would raise significant WTO questions if a WTO member state were to treat, this pen, if imported, fundamentally less advantageously than it were to treat competing pens manufactured by its own domestic manufacturers. Okay, so with these two non-discriminatory sort of pillars or principles in mind, let me then slightly transition to U.S. laws and some U.S. agreements that buffer or at least are relevant to what you probably are reading all about today. U.S. tariff laws go back to 1789. They're not new. These laws are incredibly complicated. They're incredibly challenging to write, to apply, and to interpret. Some of them actually overlap with each other. Now, all is not lost because one of the key benefits, for example, of free trade agreements, like, for example, the United States Mexico Canada agreement, right, which is obviously the current version of what historically had been referred to as the North American Free Trade Agreement or NAFTA. Well, NAFTA then and USMCA now provide for significant reductions in the tariffs that apply to articles that originate from other signatory states, be it Canada, Mexico, or the United States, or if not significant reductions in those tariffs and outright eradication of those tariffs, reducing them literally to zero. And there are still, and obviously 2025 has been an extremely dynamic year, to put it mildly, involving tariffs. Still to this day, though, USMCA benefits, for example, Mexican origin items and Canadian origin items to a significant degree, even today, importing articles that originated in those countries in the United States because in the United States laws right now, there continue to be carve outs and exemptions for articles of either Mexican origin or Canadian origin that qualify for USMCA privileges. That's a key point. Don't lose sight of that. Um, but countries that do not have free trade agreements or other preferential trade agreements with the United States have actually not had it, I guess, comparatively speaking, as well as Mexican companies exporting to the United States, Canadian companies exporting to the United States. Okay. Some examples of tariffs. Well, you could probably walk around your home, walk around your places of employment, and you can see and understand that there are multiple examples everywhere at the consumer purchase level, at the retail level, at the industrial level. In 2025, I can tell you that U.S. tariffs coming into 2025 were already very, very, very low. And in most instances, they, even without preferential trade agreements, were either already at zero or low single digits. Okay. Today, if you set aside our trading partner countries with whom we have preferential agreements, as in the USMCA, on the one hand, and countries like China on the other hand, we are now looking at an average effective tariff rate, somewhat, across the board statement, setting aside the two extreme examples of about 15%. So if someone says, my goodness, what's been going on in the United States this year with tariffs, again, setting aside our preferential trading agreement partners and setting aside countries such as China, we really have seen an increase of either 0% tariffs or low single digits to 15. It's a big change in how the United States has gone about its commercial affairs. I'll cite one specific example, then I do want to get into current events involving tariffs because next week is actually a very big week. Some of you may know why, but I'll hold you in suspense for a minute. Um, automobiles. Automobiles. Anyone who has considered buying an automobile in the United States, especially in the second half of 2025, has certainly seen some price pressures, as it's stated. I've actually read a lot of reports on this, and many economists believe that today, right now, if you were to go down to your local car dealer and whatnot and start looking at the prices of the vehicles there, that again, on average, this is an average discussion, not a high, not a low, but average. The typical car right now, new car that is, the typical new car being sold in the United States right now is looking at approximately a $7,500 impact by U.S. tariffs. That is to say that the price that you would see on the sticker is approximately $7,500 higher today than it would have been, say, a year ago, largely due to tariffs. Again, this is an average. It's not a high, it's not a low. Yes, there are differences between a Ford and a Ferrari and whatnot, but that would be the ballpark average, $7,500 approximately. Okay, current events involving tariffs. Well, we've all you have to do is open up your internet, and you probably saw that again first thing this morning. Yes, President Trump and President Xi, if they talk, are going to discuss tariffs. But a little bit closer to home, next week, in an extremely rare event, extremely rare, the United States Supreme Court is hearing oral arguments next week on legal challenges to the stated legal grounds that President Trump has cited as being the legal basis for a lot of the tariffs that he has imposed throughout 2025. Now, As I said a minute ago, the US tariff laws are a bit complicated. These legal challenges are challenging what is referred to as the International Emergency Economic Powers Act, IEPA. You probably have seen the acronym. It's a 1977 law, never been used to increase tariffs by a president the way it has been used and cited in 2025. So IEPA has been the key legal basis that President Trump has cited for a strong majority of his tariffs this year, but not all of them. And again, this is where it gets a little bit complicated. IEPA is not the chosen legal vehicle, if you will, for all of his tariffs, but most of them. His resting these tariffs on IEPA has been challenged in federal court. That federal court challenge has gone to the Supreme Court. There are oral arguments early next week. They are there. It's going to be really interesting, really fascinating. And for those of us who do this for a living, we will be making a big pot of coffee and listening to oral arguments where and how we can find them. I'm not going to try to crystal ball this. I think both sides of this argument, and that is to say, IEPA does allow and support these kinds of tariffs. IEPA does not. Maybe IEPA allows not these tariffs, but maybe those tariffs. I don't pretend I really know what's going to happen, but I do expect a decision quickly, probably by the end of the year. Stay tuned there. Let me just very briefly, in the time that I have left, and I see it's probably waning, talk about trade sanctions. Trade sanctions are a bit more related to export controls than they are to tariffs, but they're yet a third category of trade laws that are very dynamic and very active today. Sanctions are laws that restrict the ability of persons or organizations to access financial systems. So the United States, for example, has significant sanctions laws that prevent block is actually the term that's used that block sanctioned persons from accessing the US financial system. So a sanctioned person or a sanctioned company cannot come to the United States and open up a bank account with a US bank. That actually would be blocked by sanctions laws. Sanctions laws also apply to property that a sanctioned person or a sanctioned company might have an interest in. And by property, I mean literally it could be anything from a bank account to a car to a building to a house to an airplane to a yacht. Okay, so over the last, for example, almost 4 years, we've probably been reading a lot about the United States is assessing and imposing sanctions on certain Russian companies, Russian persons, Russian organizations, even Russian government agencies. This is all a reference to U.S. sanctions laws that block access to the U.S. markets, financial systems, and that prevent U.S. persons from dealing in the property in which these sanctioned persons have an interest. I'll simply close on this note. As recently as I believe end of last week, President Trump announced new sanctions on two major Russian oil companies, Rosneft and Lukoil, undoubtedly as a way to try to increase pressure on the government of Russia with respect to the situation in Ukraine. I will also say that there's been some recent developments involving the U.S. embargo of Cuba. I bring this up just to also demonstrate the breadth of some of these sanctions. They can apply literally in the case of Cuba to an entire country. And with that, I appreciate your time, attention, and patience. Thank you.
Thank you so much. We appreciate your time. So valuable to learn insights, so accessible to everyone for you sharing out in this webinar today. Thank you so much for that, Professor Bowen. We are ready for some questions, and I see we already have the first one from Christopher. Go ahead and unmute yourself if you would like.
Hello, everybody. Thank you, Professor. I have a question. I'm in San Diego, and I've been in import-export for like 15 years. And I studied in Mexico, and I specialize in Mexican side of the law. I've taken U.S. Customs courses and whatnot. Uh, I was wondering, is there any way you can share your email so we can connect outside of this? I just had a couple other questions. Maybe you can share.
Yeah, sure. I can get that to you. Happy to. Happy to. I can work with Felina to get that to you, Christopher. Sure.
Yeah. I mean, that's basically it. I just wanted to get your information so we can connect. I have a class at, in 10 minutes, but that's basically what I want.
Okay. All right. I certainly don't want to make you late for your class, especially if it's at the University of San Diego.
Right.
Right. Thank you. Javier, I think you were next with your hand.
Thank you. Good afternoon. Two quick questions, please. The first one would be, am I correct in thinking that the Constitution gives Congress the power for exports and tariffs that delegated it to the executive? And if that is true, what would the judiciary be? Even listening to an argument here whether the executive has power.
Sure. Was that your first question or was that two
Just
questions?
the first one. No, that was just the first, please.
Oops.
Just that was just the first question. I might be freezing. Hello?
I'm so sorry. I think I froze. Sorry, Javier. Was that one question too, or are there
One,
more?
just one.
One. Okay.
That one, just one, please.
Okay. Sure. So very quickly, it's a great question. That fundamentally is one of the key issues up in front of the Supreme Court next week. So just because Javier, you asked this question, one of the key fundamental constitutional challenges right now is that on the one hand, the Constitution gives Congress exclusive power to regulate trade between nations and to levy duties. Duties, we call them tariffs now, but they're essentially interchangeable, at least for this purpose. But over the course of time, and including in the various tariff laws that I alluded to, at least at a high level, Congress has attempted to delegate to the executive branch certain of its powers, including limited powers to negotiate tariff deals and arrangements with other countries. One of the key questions that literally Javier is sitting in front of the Supreme Court right now is whether or not the IEPA law from 1977 was and is a proper delegation of this constitutional power by Congress to the president. What powers specifically might Congress have delegated to the president? And if you assume and if you believe and if the justices find that there was in fact a delegation properly done of certain powers, did President Trump exceed the boundaries of that delegation?
Phenomenal. Thank you.
Mhm.
Okay, thank you. And then I think Ms. Guerrero had her hand up next.
Yes, good evening. Thank you, Professor Bob, for his spectacular presentation. It was really understandable and really easy, dynamic. And well, my question is about the export controls, the non-discriminatory effects, and also with the situation actually that Javier told us, and you explained before, about the current situation of the debt of United States and how affect the other countries. So, and with the reciprocal tariff and the export controls, I want to ask you if you think is a good strategy to pursue a fair reciprocal situation with other countries to minimize this debt of US, and also like fortifying the dollar, and that affects in the entire world. And I think that is important to also to reduce like bureaucracy from permissions, legislators, to create this
Yeah.
dynamic. And I think, what do you think about the export controls, not only the hardware, the software, but also like pursue a more export for example, pulp paper, and I don't know, a service from small companies. What do you think?
Yeah, two really good questions. Let me try to address the export control question first. Export control laws, like any other major policy undertaking, are not perfect. They are not perfect. There are some limits on their success, and there's limits on what they can do. There's limits on what they can accomplish. If you look at the historical export control laws of the United States, as I indicated, they literally go back to the colonies. However, since World War II, it's been very clear that most of U.S. export control laws since the Second World War had to do, at the end of the day, with national security. Think about the immediate post-World War II era, the Cold War, the United States, trying to isolate the Soviet Union and its allied countries while fortifying the commercial, the economic, and the manufacturing base in the United States and countries that were allied with the United States. That is the fundamental policy background, and it was the policy background for years and years and years and years and years. That is still with us today. Now, national security being safeguarded and protected by export control laws is itself a dicey proposition because export control laws, by and large, do not work if they are unilateral. For export control laws to be effective, there has to be more than one country enacting them. Because if it's just one country unilaterally imposing export control laws, it's not difficult for trading partners to circumvent them simply by going to other countries to get the supplies they need. No, and this is not a new problem. This is not a new concept. This is not a new restriction. But I think that it is more meaningful now than ever in the context of the technology tensions that I think are clear between the United States and China, for example. By the way, too, I should also point out, I made brief reference to this. China itself is also now starting to flex its muscles on using its export control laws, largely for industrial policy reasons. But, China has been on the receiving end, if you will, of significant restrictions under U.S. export control laws, and not just U.S., but other countries' laws as well, too. They've actually learned a few things about export control laws themselves, and now they're more and more going on offense with their own. So whether this is an effective national security tool, I'll let you decide. Is it discriminatory? Yes, but there are. I think there are other considerations at play here. Now, with respect to your tariff question and what that does to the currency rates, and the very question that you asked, I think implies that you know that there are all kinds of currency manipulation measures that countries can and do engage in to either try to augment or to buffer their perceived trade in goods deficit or surplus. And that's going on clearly right now. By the way, I should add the reciprocal tariff idea, it's a bit of a misnomer. They actually were not reciprocal. But one thing that has been a bit of a surprise to me is that in 2025, the United States' main trading partners have not retaliated against US exports with their own tariffs, the way I think we thought was likely, say, like in the first quarter of this year.
Thank you so much. I'm going to jump in here because we are almost out of time. We have a couple questions left. Before we hit those, I'm going to take a moment to share my screen and just share a little bit about our office background here. Again, you can follow us on social media at USD Law LLM. If you ever want to learn more about our programs, what we offer, or be up to date on whatever webinars we host, such as this one. And you also have my email address if you're ever interested in an LLM program, if you already have a JD or a practicing attorney looking to deepen your expertise. We also have a Master's of Science in Legal Studies program for anyone that does not have a JD degree but wants to learn more about the law without becoming necessarily an attorney. They can learn with the law school here as a Master's of Science in Legal Studies. The QR code here is the link to our brochure with all of our programs if anyone is interested. So I just wanted to throw that out there. And now I don't know how to get back from this. So everybody, please enjoy the wonderful view of this information. Write down my email address, scan the QR code, and I have everyone back here. So I will just leave this up. Professor Bowen, do you have time for a couple more questions? Perfect.
I do, yes.
I will start with one in the chat and then we'll get back to our two raised hands. We have a 2L student who is a JD MPA student from Syracuse Law. And they're wondering, what would you recommend to someone who wants to break into the global trade industry? Are there any specific internships that you would recommend?
Sure, sure. Well, first of all, as a 2L and as in law school, excuse me, take every single international law class that Syracuse School of Law or any school of law, whichever one you're going to, offers. Take every single class in their international and comparative law curriculum that you can possibly get your hands on. In terms of internships, I think any internship either at a U.S. federal government agency would be wonderful. There are any number of international organizations, either in New York or in Washington, D.C., that are very active in international trade now more than ever. You know, whether it is an industry business association or a law firm or a lobbying organization, absolutely recommend those. Even an internship on Capitol Hill. I mean, international trade is now such a dynamic subject. Lots of people who a year ago barely really knew what a lot of this was are now following this very, very closely. I would get your hands on any and all opportunities because this is becoming a really, really hot practice area. I predict that careers in international trade law are going to be very robust in the future. That's a great thing. It's a wonderful thing, but it also means that it's likely to be competitive. And so, uh, any organization, I mean, even writing and researching and publishing articles on the subject is a great way to get started. The idea is you want to start getting concrete credentials.
Wonderful. Thank you so much for sharing that insight. I know Javier had another question, and then we have one more raised hand.
If Mr. CDK wants to ask first, I don't mind waiting. Thank you.
Thank you, Javier.
Yes, Yes, my question has to do with how will this trade tariff restrictions impact on least developing countries like African countries, um, uh, especially countries in West Africa. Used to have a program with US. It's called to facilitate the export of products. It's called the AGWA, African Growth and Opportunity
Yeah.
Act.
Yeah, Mr. Siddiqui, thank you very much for that question. I am familiar with the AGOA, the African Growth and Opportunity Act. I mentioned a couple of minutes ago that there are certain preferential trade agreements that give certain tariff benefits to partnered countries in such agreements. And I believe that many articles that were made in participating African countries, for years and years and years that were exported to the United States did enjoy AGOA benefits, including, as I understand it, reduced tariffs. Unfortunately, my understanding is that AGOA has now lapsed and has not yet been renewed. AGOA was one of these agreements. It was actually not considered a permanent agreement, as far as I know. And my understanding is that AGOA has lapsed. I simply don't know whether or not renewing AGOA is something that the administration is currently considering. So I don't have that information. But without AGOA, manufacturers, in Africa, are really in a very similar position to like counterpart manufacturers, in Asia or anywhere in Latin America, quite frankly. They would still have to consider under current U.S. tariff laws what applicable U.S. tariffs would be for items originating in these African countries that would be exported to the United States.
Thank you so much. And then Javier for our final question.
Thank you. And just very briefly, just hypothetical, I'm NVIDIA, I make $10 worth of chips, and the export says you cannot send them to China, and I made them for China, so I take an inventory loss. Do you have any red flags there? Yes, internally red flags.
Well, I'm sure the NVIDIA CFO sees a lot of red flags. Um, yeah, I don't pretend to know. I don't work at NVIDIA. I don't pretend to know really how they have been adjusting, their manufacturing. Truly do not know, but I think it's pretty clear that the last year or two at NVIDIA has been a pretty crazy time.
No, I agree. And that same $10, if I did send in post export prohibiting me, I'm guessing it's just money and jail time and maybe losing the company as a whole.
Oh, so if export control laws were to be violated, yeah, by any right. So I'm sorry. Okay, now I understand. I think what you were asking, Javier. Sure. So violating export control laws is subject to criminal and civil fines and penalties.
Thank you.
Mhm.
Wonderful. Thank you everyone so much for joining us. I see we have some of our current and previous LLM students join us. Thank you so much. It's wonderful to see you here. And thank you for all the new faces that have joined us today. Thank you especially to Professor Bowen for sharing your
My pleasure.
expertise with us. It was really, truly valuable to be able to hear from you in this capacity. Thank you so much.
Thank you. Thank you for organizing this, and thanks to everyone. Yeah, it was very enjoyable. Thank you.